Good afternoon, everybody. Thank you for joining us. We'll get started now. I think we're about 2 minutes past 12. So Eloise, if you could just move on to the next slide. Thank you. Just wanted to make you aware of some forthcoming Surrey Law Society training. We're having a little break over the summer holidays, but kicking off again in autumn. You can see on screen there some of the sessions that we've got coming up. So a webinar on key clauses in residential leases, a private client update course at TWM Solicitors, and an online course on pensions and life policies in the context of estate planning with John Bunker. Also, in addition to that, we've obviously got our SLS Legal Awards in October at G Live. So if you haven't already booked your table or your place for that, please do so. You can view all the information about all of our courses and events at the Surrey Law Society website. Moving on just to some housekeeping notes, there's going to be a 5-minute break at around 1 p.m. If you'd like to ask a question during the session, you can unmute yourself and put your video on or turn it off, as this is a meeting. Stuart will intermittently invite questions, so that's the time to do that. Yeah, you can also use the chat box as well. Lastly, just to note, the session is being recorded and you will also be asked for feedback once the recording's circulated. So it's really helpful if you could provide some details on your thoughts of the course. So please do fill in that survey. Right, with no further ado, I will pass over to Stuart. Thank you, Stuart.
Thanks very much, Helen. First of all, welcome everybody to this Advocacy and Family Law, a guide for solicitors. You have some notes, all being well, they're fairly comprehensive, and also the slides, of which you have a copy, I think. I just want to say something a little bit about myself. Next slide, please. I'm a practicing solicitor. I've been around quite a long time. Following law degree and my 6 months in Guildford, did my articles in Nottingham and then moved to South Wales, where I practiced in a high street practice. As per the situation in those days, in the 1970s and 80s, solicitors who did court work tended to do everything. And I was no exception. I did criminal defence, family, civil, never really ventured into the other sides like conveyancing and probate, although I did occasionally dabble. My articles did involve those things. But over the years, I've become more and more specialised. So initially I dropped civil law, and then I combined criminal defence and family. But over the last 20 years or so, I've specialised purely in family and have done a whole range of things. And this particular course in advocacy covers the range that I've been involved in over a period of time. So that gives you a general background. Next slide, please. The question, no doubt you'll be asking yourself, and it's a question that I asked myself some time ago, was why do we undertake our own family advocacy? And today we're going to be starting off with the basics, and then we just move on to perhaps more challenging areas that we face as advocates each day. I'd like to think that there's going to be something for everyone today, because we're covering private children, care work, finances, domestic abuse, and so on. So the whole range of advocacy is to some extent going to be within the grasp of what we're going to be doing. So feel free to ask questions. Perhaps it'd be easier if I just ask a particular point for you to fire the questions at me, and I'm very happy to deal with those. Now, the question is, why do we undertake our own family advocacy? And it was a question that came to my mind what seemed like many years ago, when there was a district judge, I think it was probably in the days of registrars then, who was addressing a group of family solicitors in London. And he started off by saying, why do you, as solicitors, not undertake your own advocacy? Why do you always send it out to counsel? And I've been involved in a number of firms over the years in terms of training and so on, and some of them have taken the view that they do not do their own advocacy. It's passed on to solicitors, and that's their policy. But most firms have moved towards doing at least some advocacy for themselves and keeping it in-house. And so the first question, of course, is, do we do our own advocacy or do we not? Next slide, please. And I think there are 4 reasons why we should do our own advocacy. And I'm quite passionate about solicitors undertaking their own advocacy, because I think if you do it, there are reasons for doing it. So the first is that there are financial benefits, I suspect, to the advocate themselves, but perhaps more particularly to the firm. If you send it out to counsel, inevitably counsel gets the fee. Therefore, if you do it yourself, in terms of pure financial benefit for costs, it will be kept in-house. If anyone who's listening and viewing now is thinking about, say, care proceedings, in care proceedings, the money is made, as it were, in advocacy. There is usually a fixed amount of fees for preparation. But if you do your own advocacy, of course, that's of enormous financial benefit to the firm. The second reason is that you, as a fee earner, are familiar with the case and with the client. And I think that you are best suited to present the case to court, obviously within limits, and perhaps making sure, of course, that you're confident in doing so. But if you're familiar with a case, then you should know your case well. But perhaps more importantly, familiar with the client. Let me tell you about a friend of mine. We'll call her Suzanne. Suzanne came to see me a few years ago and wanted to go through divorce and financial matters, and wanted me to recommend a particular firm of solicitors who would help, which I did. And time passed, and maybe 6, 12 months or so, I saw her and asked how she was getting on. And she said the firm of solicitors, the solicitor in particular, was really good and she was really happy. However, she'd just been told that the solicitor would not be attending court personally. It would be passed on to someone else. And she did express disappointment. She said, first of all, they know my case. And secondly, they know me and they know how I feel. And the chemistry between us has been really good. And so to have someone come in, if you like, at the last minute is not particularly great for me. So that's, if you like, a good enough reason for saying for you to undertake the case at court as well as undertaking the case in the office. The third reason is that I personally find that doing the case in advocacy terms is really good fun and really helpful and very fulfilling professionally. Now, I happen to have been brought up with criminal defence, and therefore criminal defence, we were undertaking our own advocacy on a regular basis. And therefore I was fairly used to advocacy in doing criminal work. However, family work has a flavour of its own, but I do find that dealing with a case from beginning to end is really enjoyable. And I come out of court thinking, I've done this case from beginning to end. Whatever the outcome, you always feel that you've done a great job in its completion. The fourth reason is for future prospects. Now, it may be that this doesn't apply to you specifically, but if you were a young solicitor and wanting to move on, the chances are that you will not necessarily stay in one firm. And if you're dealing with family work and can undertake advocacy, that will increase the prospects for you as a solicitor in terms of obtaining employment and progressing within the firm. So those are the 4 reasons why I think you should undertake your own advocacy. Now, to some extent, it depends on you and the confidence that you have. And that's why I initially labeled this course Gaining Confidence in Advocacy, because to a large extent, that is what it's all about. Next slide, please. Now, how do you gain confidence? And I'd like to put to you a number of matters that will hopefully explain my thinking, but also maybe persuade you that it's something that you want to do. It could be that it's something that you want to do, but you feel that there are limits to how much you can do. It could be that you could do the first hearing. Excuse me, I turn off my mobile. And but after that, you feel that maybe you want to pass it on to counsel or indeed somebody else within the firm. But sometimes there is an attitude when it comes to advocacy. You either can or cannot do it. Or perhaps more importantly, you do it and you sink or swim. I think that to some extent that does have an argument. But I think it's fair to say that the more you do it, the better you become. But in order to establish whether it's for you, and that could be on the basis of I've never done it before, but I want to do it, or I see the future in advocacy and therefore I want to start. I think there are things that you can do to help yourself. The first is observing. Don't think that by going into court, you have automatically the ability to undertake advocacy. I always say that an expert was always a beginner. And therefore, everybody starts as a beginner. And so to observe other people is an immense help. So if you are thinking of doing advocacy, observing others. Now, as an article clerk, as we were called in those days, we have the opportunity of going to court on a regular basis, usually with counsel, but perhaps with our supervisor. And I was the sort of chap that was keen to observe as much as possible. But when you observe, you don't simply sit there. You ask the questions about why things are happening the way they are. Why is the advocate for the opponent doing it the way he is or her? Why it is the judge doing these things? So simply by observing and maybe asking the person that you go with a few questions afterwards would really help. The second is to seek advice. If you are going to court and you're not sure what to do and how to do it, then seeking advice is a really helpful way of doing it. And I've been working in various firms over the years, and people have come to me and have gone to others, and they simply feel embarrassed about seeking advice. And I encourage them by saying, no, it's so important to seek advice. That's how you learn. And therefore, if you're not sure, seeking advice before you go and maybe reviewing it afterwards is a great way of doing it. As a newly qualified solicitor in South Wales, I was rather nervous about undertaking work. And I happened to meet a friend whose dad was a lay magistrate, a very experienced one, as it turned out. And I said to the friend concerned, his name is Martin, and I said, Martin, would your dad spend a couple of hours with me one night, giving me some advice on what he thinks is a good advocate? As it turned out, he was willing to do that. And I wrote a lot of the things down afterwards. And I have to say that some of the advice that he's given me, I practice today. So seeking advice from people within the firm, or indeed in other firms, seeking advice from people like a magistrate is really helpful. It is a learning curve. We're beginners. And if we start on the basis of we are willing to learn, that will be a great help. I think there are three issues as you prepare to go to court. And the first question is how you do it. So the first contribution I would say is this: know your court. And we'll be looking at the court in a moment. Know the procedure. In other words, are you familiar with what's going to happen in the case that you're conducting? And the last one is know your case. In other words, prepare well. Know your court, know the procedure, know your case. So let's explore those particular headings in more detail. Next slide, please. Next slide, please. This is Nottingham Family and Youth Court. It happens to be just one of a number of courts in Nottingham, and I practice in Nottingham and in Derby and in the smaller courts. But that's a sort of a typical court building. Now, it may be that you practice in an area and you would, if you were an advocate, attend that court on a regular basis. It may be, like I am, attend a number of courts. But the important thing is to know how that court operates, what the physical layout is, who the people are, and what the courtroom is like. Next slide, please. As you go into court, that's just a typical courtroom. You get into court, and behind that door is a courtroom. And you're going to be appearing for a client as an advocate behind that court, behind that door. Next slide, please. Now, what sort of courts are we talking about? If you're a family court advocate, the chances are that you will appear before 3 sets of tribunals. Now, if you make an application in a family case, it could be a family, it could be financial, it could be care proceedings, it could be private proceedings, it could be domestic abuse. Your application goes into court, probably by means of either filing it physically or through the internet. And it lands on the desk, if you like, of what is called a gatekeeper. The gatekeeper then has to decide where your case is going to be heard. Lay magistrates, district judge, or circuit. And so much will depend on the nature of the application, and we'll be looking at those applications in more detail. But as a rule of thumb, it's a straightforward case. It goes before the lay magistrates. If it's more complicated, it goes before a district judge. If it's even more complicated and maybe has particular issues, it goes before a circuit judge. Now, there will be certain sorts of cases that find themselves almost automatically. So for example, if it's a financial matter, the chances are that it will be listed before a district judge because they tend to deal with financial matters. If it's a care case, and say, for example, it's a non-accidental injury, then it would automatically go into the circuit judge's court. If it's a private proceedings case involving contact with no particular issues, the chances are that it will go before lay magistrates. So the gatekeeper will decide. And when the notice of proceedings comes out, it will tell you normally where the case is going to be heard. Next slide, please. I want to take you now into those particular courts. And I want you to think about what it would be like as an advocate. Now, in your particular area, you may not have lay magistrates operating. On the other hand, you may find that lay magistrates operate on a regular basis. It really does depend on where you're practicing. But this is a typical lay magistrates court. Now, I'm mindful of the fact that the formation of a courtroom varies very much according to the particular court. And therefore, I'm addressing the various options. So what we have here are lay magistrates. There's likely to be in family proceedings either 2 or 3. Lay magistrates are volunteers of the community. They are not professional lawyers, and the only professional lawyer in that courtroom, other than yourselves as advocates, will be the legal advisor. And the legal advisor advises the magistrates on the law and procedure. On the facts, the lay magistrates take responsibility. And so they sit as a threesome or twosome. You address them as your worships or sir or madam, depending on how, whether it's a man or woman. And then as advocates, you will sit on the front bench and you'll see where the advocates are in that particular diagram. And behind you are your clients. And one of the aspects of that particular layout is that, of course, if you're an advocate, then you're going to have to turn around to speak to your client. I personally find that more complicated, simply because having a client by my side is usually very helpful. And we'll come back to that in a moment. The proceedings are likely to take place when everyone is seated. Occasionally, you'll be expected to stand up, but that is a typical lay magistrate's layout in, for example, in Derby, where I practice. Next slide, please. And that's a picture of the sort of court that you would find lay magistrates. So you'll see 3 magistrates with a chairman in the middle and with a legal advisor at the front and the advocates on the front bench, and out of view will be your clients. Not all courts are as formal as that, but that's fairly typical in, say, Derby and other places where I've been to. Next slide, please. Another option in the lay magistrates court is the formation of the courtroom itself. This is one what I'd describe as the C formation. So you'll see the magistrates sitting as a threesome, duly marked, and everybody else sitting around the C-shaped formation of the table. You'll see where the witness box is. And this is my personal preference, because that way your client will be sitting next to you and you can discuss things easily without any problems. And of course, you'll see the legal advisor sitting around in that formation. Next slide, please. And that's a photograph of now what is called, well, it used to be called the Burton-on-Trent Family Court, defunct and closed some years ago. But the formation is exactly the same. So if you come to Nottingham, the chances are that the family court will be made up in that sort of way. So you'll see the lay magistrates at the end with the parties round the C shape. Remember, of course, that the proceedings are in private, and therefore the only people who will be in court are those who are involved in the proceedings. Next slide, please. The next court is the district judges court. Now, district judges often deal with a whole range of family cases. They could be dealing with a care case, a private children case, a financial case, or a domestic abuse case, or indeed anything else within the family timetable. In this particular formation, we have the district judge at the head of the T shape. And on one side, the advocates for the applicant, on the other, the advocates for the respondent. And all parties are seated. Up until recently, the district judge was referred to as sir or madam. Now they're called judge. So if you were addressing as an advocate the district judge, you would be saying, "This is my application, judge." These are the facts, Judge, and so on. Everybody's seated, and it is almost like an office arrangement. And I personally find that that's really helpful from a client's point of view because there is less formality. Next slide, please. And that's a photograph that I asked for permission to take some time ago. It could be that the formation in your court is slightly different. But what it means is it's more like an office rather than a courtroom, and people sit and feel relatively comfortable. Advocates tend to sit nearest the judge. Some courts have a security barrier between where the advocates are and the district judge. Next slide, please. The next court, and perhaps the likely court that you will appear in, is the Circuit Judges Court. A circuit judge is a professional judge, often formerly a barrister, but could be a solicitor. Historically, district judges were ex-solicitors and experienced solicitors. Now they could be ex-barristers or ex-solicitors. Likewise with the circuit judge. And in front of the circuit judge is the court clerk, who is dealing with administration of the court itself. And on the front is the advocate, that will be you. And behind you will be the clients, the parties involved in the case. You're likely to be seated, but when you address the judge, you will stand. Or if the judge addresses you, you will stand. That's a general exception. Now, instead of calling in sir or madam, you will be calling the circuit judge your honour. And they are, of course, the more senior of the judges, usually have a lot of experience. Circuit judges in Nottingham and in Derby tend to deal with the substantial amount of care proceedings, particularly the complicated cases. Next slide, please. And that's a typical circuit judge's court. Next slide, please. I want to show you a photograph of a picture that was taken during COVID, hence the yellow and black symbols. But the reason why I'm showing this picture is it shows where you are as an advocate. You will be sitting on the front bench in the middle of the picture. On the right-hand side will be your clients, and you'll be addressing the bench on the left-hand side. There's likely to be a microphone, but you'll see there's a what looks like a TV set, a screen. They are more and more common, but in that particular case, it was intended to allow some witnesses, particularly expert witnesses, to give evidence remotely. And they are a common feature because in family proceedings, certainly in our area, a lot of proceedings are conducted remotely. And so it could be that various parties will not be attending court in the courtroom itself, but will be sitting maybe at court or in the solicitor's office. Next slide, please. Now, I'll just pause there for a moment. And just simply to reiterate what I said earlier about knowing your court. Because if you know your court and you know where to sit and you know how to tell the client how to sit and what to do and so on, that gives you an immense amount of confidence. If you don't know, and sometimes the first time you won't, especially if you're a newcomer, then of course it can knock your confidence. And you may say, well, I'm not sure whether I want to do advocacy because I couldn't even get the basics right in terms of where I sit. I had a personal experience many years ago when I first came into the law. I went to, just happened to be Loughborough County Court with counsel, very experienced counsel, and I sat at the back of the court. I'd never been in a courtroom before, and counsel waved me forward and said, "You have to sit there, you instruct me." I felt a complete fool, but I didn't know any better. No one actually instructed me where to sit or what to do. It was a long time ago, and I've never forgotten it, as you can imagine. And so therefore, the whole idea of knowing where to sit and where people conduct themselves is a very important part of starting as an advocate. You can do it by observation. You can do it by advice. But if you know what to do, it's an enormous start. I'll just pause there if anybody wants any questions on the particular court itself. No, okay, thanks very much. Let's look at the second feature of being an advocate, is know the procedure. Next slide, please. When you attend at court as an advocate, it could be that there will be a particular application before the court that stands out. Every case is different, and almost all applications will have a flavour of its own. But I just want to list the sorts of cases that you will conduct as an advocate. And this crosses the boundaries of care proceedings, private children proceedings, financial application, domestic injunctions, and so on. And therefore, all these could apply in one form or another. The first application is a without notice application. That can arise and is more perhaps commonly a feature of domestic abuse applications. So if you're making an application for a non-molestation order, it could be urgent. It could be that if you were to give notice to the other side, because normally notice has to be given to your opponent, to the applicant, and you have to give them a period of time in which to prepare their case. It could be that your client is fearful that if they are served with the papers, there will be a repeat of the allegations. And you, as an advocate, have decided that you will appear before the court on a without notice. In other words, you prepare the papers, the court will list it, and it may go before the lay magistrates, it may go before the district judge, or even a circuit judge on a without notice basis. So as an advocate, if there's nobody going to attend court, you're on your own. You're there with your client. And so, for example, historically, district judges have tended to deal with domestic abuse papers on a without notice. And so you will present the papers to the district judge, who will then say to himself or herself, is this urgent? Can I deal with this on a without notice basis? And if the judge is satisfied, he or she will read the papers and say yes or no to your application. It could be that there will be questions, but the amount of advocacy undertaken on a without notice hearing is likely to be a minimum. And it's probably going to be one of those cases where you and your client go to see the district judge in private. She has the papers, looks through the papers and says, yes, I'm satisfied it's urgent. I'm satisfied I can deal with it on a without notice basis. And therefore I'm going to grant the application. Doesn't make any judgment about whether the facts are true or not. If they have doubts, the district judge may have some questions. But likewise with lay magistrates. And so the amount of persuading that you will have to do is going to be very, very limited. Now, of course, that without notice is simply an order is made for a period of time, and the court will fix another hearing date. The papers will be served on the particular respondent, who will be asked to go along to court and answer the allegations. But between the court hearing and the service of the papers and the next hearing, of course, an order will be made. So that's without notice. And people will say, well, they're dead straightforward. You don't need to say anything. The district judge simply reads the papers and says yes or no. It is not as straightforward as it sounds. And it could be that the court will ask you some questions to justify, first of all, the urgency, and secondly, do the papers reveal a proper case? The second type of hearing is a directions hearing. A directions hearing is sometimes dismissed as something quite easy, but actually directions hearing could be wide-ranging. And for all intents and purposes, it's a hearing to establish where the case is going, hence directions. What direction is this case going? And we're living in a world in family proceedings where there are standard forms and orders. In private law proceedings, courts operate according to a set of directions, and we'll be looking at that in a moment. But the sort of directions could be, when is this case going to be heard? Are expert witnesses going to be called to give evidence? Should the parties give statements? Should there be a direction for a Section 7 report? Those sorts of issues. And invariably what happens is that the parties, the applicant and the respondent, with their clients, will come to court and discuss what directions are likely to take place. They will have, if you like, negotiations before they go into court. As an advocate, and you know as an applicant, you will start the case off by saying to the judge or the lay magistrates, the parties have arrived at an agreement with regard to directions. These are the directions. Would you please make orders accordingly? Now, of course, directions could be straightforward, but it could be that the judge or the lay magistrates will say, well, Mr. Barlow, I've looked at the directions and I'm quite happy with 1, 2, 3, and 4, but I'm not happy about the final one, and you'll need to discuss it. So as an advocate, you need to be prepared to justify the content of your directions. The next type of hearing is very similar, called a case management hearing. And for all intents and purposes, it's very similar to directions. But it's an opportunity for the court to manage the case. Courts will not simply rubber stamp, particularly the professional judges. They will have a view of their own and will want to manage it. But the directions are very similar. A contested interim hearing could arise in, say, for example, your client as an applicant has made an application for contact and there is no agreement. Dad wants contact, mum says no. And dad says, but I haven't seen my children for the last 6 months. The court process has meant that I've not been able to see them at all. Consequently, I want an urgent hearing for the court to make an interim order. And the court on that occasion will then say, I'll have statements from both sides, we'll fix a hearing, and there will be a contested interim hearing. Interim because it will not be a final order, in which case the advocate will need to be prepared as if it's a contested hearing. Fact-finding hearings arise mainly in domestic abuse cases, but also in children cases. It could be private children case, it could be care proceedings. But if parties, could be the local authority if it's a care case, or the parents, dispute what's happened, then the court may say, before we arrive at a final decision, we need to have a hearing to establish the facts of this case. So, for example, in a fact-finding hearing where a father applies for contact, the court may say, well, mum says that dad is a violent man and the children would be at risk and therefore contact should not take place. Dad says in response, no, that's just a lie and the court should ignore it. So the court will arrive at a decision to have a fact-finding hearing to decide the truth. Having heard the truth and made a decision on what the truth is, then of course the court will then move forward. The last type of hearing is a final order, a final hearing, when of course we'll bring the proceedings to an end. And as an advocate, your job, if you're an applicant, is to obtain an order that you're seeking. As a respondent, it may be that as an advocate, you'll be resisting that and asking the court to make an alternative order. So you'll see, in terms of advocacy, each case is different. Next slide, please. What sort of cases are we talking about? Next slide, please. Well, if we're talking about private children applications, then of course, as we've looked at already, those applications can come before the lay magistrates. Remember, they are volunteers, trained to some extent, and some of them are very experienced. Or it could be before a district judge or a circuit judge, or even a high court judge, in which case you're likely to be instructing counsel in any event. Next slide, please. What sort of orders would you normally expect in private children proceedings? Next slide, please. Well, this is a list of the sort of orders you'll be seeking. A child arrangements order to establish where a child is going to be living. Is it going to be with mum or dad? And also the amount of contact the father will have. And the court will listen to those applications. It could be a specific issue order. That could be relating to, say, the court is directing that the child attends a particular school, or whether the child goes on holiday. And it could be to do with the handing over of a passport. The whole range of orders can be contained in specific issue orders. I did a contested hearing on a relatively simple matter not so long ago, where the father wanted to take a child to Florida, to Disney. And mum said she objected. And she gave her reasons for that. And the matter was heard, interestingly, before a circuit judge who heard the evidence. Father gave evidence, mother gave evidence, and the court made an order for the child to be allowed to go to Florida for 2 weeks holiday. And that's a sort of situation that would arise, and sometimes they can be quite emotive. It could also be a specific issue order regarding whether a mum and child moves from one part of the country to another, and therefore is seeking the court's help in order to obtain an order because the other parent is objecting. A prohibited steps order is an order that prohibits a party, a parent, or somebody with the rights to care for the child to do certain things. So, for example, a mother wants to move to Pakistan, and dad says, "No, I want you to stay here." In the court, she is seeking a specific issue order, but dad is seeking a prohibited steps order. Or it could be that a prohibited steps order is being sought to prevent a party attending school. Contact takes place, say, at a contact centre, but father has been in the habit of attending the school that the child has been attending. and therefore the court have been asked to make a prohibited steps order to prevent him from doing so. Parental responsibility orders are sought usually by the father who's not married to the mother. As you will know, parental responsibility happens automatically for fathers in situations like where if his name is on the birth certificate, or he's been registered as the father at birth, or maybe he's obtained some kind of parental responsibility agreement. But parental responsibility arises where a father simply wants to be able to make decisions, important decisions, like a change of name, or change of religion, or change of school, or something such as that. And of course, he's not able to do so because for one reason or another, he doesn't have parental responsibility. Special guardianship orders are sought in the event of, say, a grandparent caring for a grandchild and gives them the right. I described it as a souped up child arrangements order, giving them the right not only for the child to live with this special guardian, in our case, a grandparent, or alternatively, another relative. And I call it souped up because to a large extent, parents' views with regard to the general upbringing is excluded and left in the hands of a special guardian. So those are the main orders that you'd be seeking in a family proceedings case in private proceeding. Next slide, please. I want now to look at how you obtain a private children order. And this is where it's so important to know what the procedure is. Now, I'll be looking, and I'll be directing you to what I describe as a baseball game. All the way through this presentation, the baseball game will appear. And so in private proceedings, we've already learned that on your application for an order, in this case, private children proceedings, an application will be made for the court to hear the case. The gatekeeper will decide which court it's going to be heard. And whichever court it is will take exactly the same process. So the gatekeeper, for example, may say, this is a straightforward case. It can go before the lay magistrates. And the court will then fix the first hearing, what I describe as the first base. Commonly known as FEDRA, but the full title is First Hearing and Dispute Resolution Appointment. At that hearing, the parties will come together to decide on where the case is going. It's the first opportunity to obtain an order. And as an advocate, you need to be prepared to persuade the court to make an order that you are seeking. So between the issue and the actual first hearing, the FEDRA, the first base, is that Cafcass are likely, and we'll be looking at Cafcass in a moment, to have prepared a letter to the court. It's called a safeguarding letter. And the purpose is to satisfy the court that there are no issues that the court need to be aware of. So inquiries are made with social services and the police, and discussions are made between the parties. So when the court deal with that first hearing, it has the information to enable it to make an order. It is possible for the court to make an order immediately, provided the safeguarding letter has been seen by the court and the parties themselves. If at that first base, at the FEDRA, it's not possible to come to an agreement, the court will then adjourn the case to second base, the DRA, the Dispute Resolution Appointment. And in between the first base and the second base, the advocates will have done a lot of work. It could be that the court will have made directions with regard to the filing of statements. It could be that a Section 7 report has been directed. It could be that expert evidence has been directed. And so therefore, further work will be done between the first and the second base. At the second base, the advocate will again seek to try and resolve matters. Is it possible to obtain an order in the light of the facts as they see it? And so as an advocate, you need to be fully prepared, because as an applicant, you're wanting to have an order as soon as possible. If it's still not possible, it could be that the Section 7 report filed with the court and seen by the parties is not acceptable to one of the parties. They may insist that the writer of that report attends court, and the court will then fix a final hearing, what I describe as the third base. And that concludes the case because it hears the evidence, and we'll be looking at that in a bit more detail. So what parts do you play as an advocate? Well, in the first, the second, and the third base, each will have its own characteristics simply because of the facts being different. But it's important that if you're the applicant, you're seeking an order as soon as possible. As a respondent, you'll also be seeking an order that may be slightly different to the one that the applicant is seeking. So you'll see the importance of knowing the procedure. It's a massive incentive to be able, if you know the procedure well, you know exactly what to ask the court to do and what options are available to the court, because you know the sort of orders that are available to the court. Next slide, please. The next type of orders that you will be seeking as an advocate, it could be that you deal with financial orders on a regular basis. It could be that you don't deal with them very much at all. But the normal place of financial orders will be the district judge. Certainly in the area that I work in practice, the circuit judge does very few in terms of financial orders. But your area may be different. And if it's a particularly complicated financial order, and it may be there's an awful lot of money involved, it goes before the High Court. So what sort of financial orders is the court going to be asked to make? Next slide, please. Well, it could be that there will be, so the types of orders will be, could be maintenance on an interim basis. It could be lump sum. It could be transfer of property, pension orders, orders with regard to cohabitation, and Children Act Schedule 1. In other words, a child is seeking an order themselves against a parent. Let's look at the procedure involved, because the procedure is exactly the same for all of them. Next slide, please. In this case of a financial application, again, the application is filed and the court decide on where it's going to be heard. Now, if you're in London, it may be that the options are somewhat different. But in the provinces where I operate, the chances are that it will go before a district judge, certainly. And the baseball game comes into play again. So the application is filed and a direction is made for financial details to be provided by both parties in the form of a Form E. And the court will fix a first hearing, an FDA, more correctly known as the first directions appointment. And at that hearing, the advocate will be asked to attempt to negotiate a settlement. Mum is asking for an order. Dad is resisting that order. But the court does have information. But the court may not have sufficient information. And so at that first hearing, you as an advocate will be asked to persuade the court to make certain directions. It could be that more details are required about the value of a property, say a house, or maybe a company, and the court will make directions for that to take place. It could be that the court need further information about other matters, such as the value of a pension. So in other words, at that first base, the court is not in a position to make an order simply because it doesn't have sufficient information. So the court will be asked to direct that that information is provided by the second hearing, otherwise known as a second base, better known as a FDR. And the FDR is a financial dispute resolution hearing. And the second base is a fundamental part of the process, because at that hearing, the district judge, for example, will be asked to indicate on the basis of the information on file what sort of order should be made. And that's a very helpful way of dealing with a case. Now, of course, the court assumes that it has all the information. So it has all the values, it has all the details about the parties' income and outgoings and so on. Wife is asking for an order in certain terms. Husband is asking for an order in different terms. And the district judge will want to hear from the advocates. And having heard from the advocates about their client's case, the district judge will give his own view or her own view. And that's really helpful. The district judge may send the parties out, and the parties then go out to try and negotiate. They've heard what the district judge has said. He or she has all the information and is able to say, this is the sort of order I would make. I haven't heard any of the evidence, but what I've heard is from the advocates as to their views, and also in regard to the details of the case. What is in, if you like, the financial pot? And the district judge may say, I would award this. I haven't heard the evidence, but I award this. So the parties then negotiate. If they can come to an agreement on the basis of what the district judge has said, then they can come back to court and they can then ask the court to make an order in the agreed terms. If, on the other hand, the parties can't come to an agreement, then the case is moved on to the third base, the final order, when evidence will be called. Parties are likely to have perhaps provided statements of their case, and the court hear the case. The interesting thing is that the district judge who heard the case at second base at the FDR will not be the same judge as the judge who hears the case for the final hearing, this third base. Because, of course, the first district judge has expressed a view. So he's therefore unable to hear the final case. At the third base, as an advocate, you will be presenting as an applicant all the information, calling your client to give evidence, and the judge will then give a view in terms of the order and why he's made that order, which brings the proceedings to an end. Next slide, please. Injunction orders, and once we've been through these various orders, we'll have a pause for lunch. Injunction orders can come before lay magistrates. There was a time when district judges used to hear all injunction orders, and but now lay magistrates quite commonly in our area hear cases between the parties. Could be a district judge, it could be perhaps exceptionally a circuit judge. Next slide, please. What sort of orders? A non-molestation order or an occupation order? A non-molestation order is simply an order directing one party not to do something. For example, the applicant, and we'll say it's the woman for the moment, the woman is seeking an order to have protection, to prevent the man from molesting her, assaulting her, intimidating her. And there's a whole list of allegations and orders that can be made. And the court will hear that case and make an order accordingly. Could also be an occupation order. In other words, the man has been violent towards the woman, and the woman is seeking an occupation order to exclude the man from that particular house, and therefore is asking the court to make those orders. Next slide, please. Again, we're back to the baseball game and knowing the process. The application is filed, a decision is made as to which court hears the case. It could be a without notice hearing that I referred to. If it's a first base, it will go on to the second base when there will be a first hearing, where all the parties will come together and tell the court what they think about the case. And then if they can't arrive at an agreement, then it could be a final hearing where the court will hear the evidence and decide on the truth or otherwise of what's being said. One of the features of injunction cases, particularly non-molestation orders, is the court may ask the person who's accused to give an undertaking not to repeat the behaviour, irrespective of whether that person accepts the allegations. And it can be resolved by way of an undertaking. So applicant is seeking an order. The respondent is asked to give an undertaking not to do certain things. It's not a question of don't do it again, because of course he denies it in the first place. But a lot of cases are resolved by way of an undertaking. If the man, for the sake of argument, is unwilling to give an undertaking, it goes on to the second base, the first hearing, where the court will hear from the parties and decide on whether it's appropriate. Could also be a final hearing too. And so the court will hear the evidence and make a decision one way or the other. Next slide, please. In terms of care proceedings, it may be that you don't deal with care proceedings, but if there are care proceedings, then of course there could be a care order, a supervision order, or a placement order. Care orders gives the local authority parental responsibility to look after a child and make decisions for that child. Could be that the child is removed from the parent's care on the basis that the child is at risk of significant harm. A supervision order will enable the child to continue to live with the parents, but under certain restrictions, and the local authority are able to be involved under that supervision order. Or a placement order which frees up the child for adoption. Next slide, please. As an advocate, and it may be that you are involved in care proceedings yourselves, I would say that this is probably one of the most complicated and sorts of areas of care as an advocate, because very often the speed at which care proceedings take place in the beginning could give rise to an initial application. So a child is at risk of significant harm because of the way the child has been treated by the parents or parent. An application is filed by the local authority, who will then seek an order. And there will be a case management hearing, the first base. And the court will then, is likely to make an order of some kind. And that's where the advocate comes in. But sometimes the advocate has to fight a case without very much information, and it tends to be one-sided. And orders can be made on an interim basis, like we mentioned earlier about interim contested. Sometimes the court has to hear the evidence. Sometimes the parents concede and the child goes into foster care. And then the case is adjourned with the court making case management directions. So it goes from the first base to the second base. At that second base, an issues resolution hearing where the court decides on what orders are to be made. And if no orders are made, then of course it can be made at a final hearing, the third base. In between all three bases, a lot of work is put into this, particularly by social services. It could be there will be statements by various parties, could be by experts, it could be a fact-finding hearing. But at each point, and each set of proceedings, hearings, the advocate will be expected to represent their client. Next slide, please. We'll pause there and we'll come back to the this question of a judge or lay bench, spot the difference. And what is the difference? We've looked at a lay bench, we've looked at a district judge. What differences are, as an advocate, would you see in the two particular types of court hearings? But we'll have a 5-minute break and I'll see you back in a moment. Thanks very much. I just pause there for a moment amongst those who are attending before we move on to this particular subject. Are there any particular questions that come out as the procedure process? Feel free to be able to do that and also maybe leave them to the end if that's more helpful. What is the difference between a judge and a lay bench? Well, we've described the difference practically, but how does the court hearing vary, and what's the difference between the two? Well, there are some that are fairly self-evident, like, for example, a judge, whether it be a district judge or a circuit judge, or even a high court judge, is that they are professional lawyers. The lay bench are volunteers. That's why there's an emphasis on lay magistrates, and they're expected to make important decisions, but they form a very big part of the family circuit. And certainly in Nottingham, without the lay bench, the family courts would grind to an end. And I think nationally, they're considered to be really important, simply because without them, the courts would not be able to sit. One of the advantages is the fact that whilst the judges are professionals and are employed by the government to conduct cases, the lay bench are not paid, so they're free. They have to give up their time, and they may have a little bit of expenses in terms of travel and so on, but generally speaking, they are there, and that's one of the reasons why I believe lay bench courts, the magistrates' court, will always be with us, because it is a very simple and also cheap way of organising the court system. But practically speaking, as an advocate, what is the difference? Well, the first is that with a judge, they're likely to be decisive. They sit on their own. Lay bench sit as a threesome or maybe twosome, and they need time to discuss it between each other. So court hearings in a judge's court are likely to be much shorter than they would be in a lay bench. You'll find a judge will make a decision there and then. A lay bench will retire to their retiring room to make a decision. So court hearings inevitably are going to be far more protracted with lay bench than they are before a judge. The second is the fact that when the case is conducted, you often conduct it through a legal advisor. The legal advisor is a lawyer, and they vary enormously, and they direct the bench on law and procedure, and consequently that makes the situation more difficult, because the lay bench is the bench that you are directing your responses and your submissions to, but actually the legal advisor is the person who's making the major decisions on law and procedure. The drafting of the order is much more prolonged. If it's a lay bench, an order will be made after they've discussed it and drafted it out in fairly lengthy detail. With a district judge, they're likely to make the decision there and then. It's likely to be much briefer. And so my own personal position is that whilst lay bench can be under some criticism by family lawyers, I personally appreciate what they do, partly because if you are, as an advocate, representing a client, then the judge is probably more likely to cut you short and say, I've heard you on this particular matter. All I want is to hear you on that particular matter. Or the judge will say, I've heard enough, thank you very much. With the lay bench are likely to give you a lot more latitude in terms of what you say. And so therefore, you can put your case across in the form of a client who maybe wants to emphasize certain aspects, where a district judge would say, I'm not going to take that into consideration. And so in summary, you have the professional against the, if you like, the amateur. You'll see them being far more proactive as against the lay bench who tend to be a lot more relaxed about hearing what you say. The hearings are much longer with lay benches as they are with judges. And finally, they're likely to be the sort of cases where when it comes to the order, the judge is likely to be able to make the order there and then. Whereas with a lay bench, they will take some time to be able to do that. Do I prefer the lay bench to the judge? Of course, most lawyers prefer the professional judge. But of course, there are aspects to it that are different. And one of the aspects is you're giving so much more latitude by a lay bench than you are by a judge. And so sometimes you have a case that doesn't actually stand up terribly well, whereas the judge will probably point that out to you there and then. A lay bench will simply listen to you politely, then make a decision, having retired to discuss it. So those are the differences. Anybody want to come back on that at all? No, thanks very much. Next slide then, please. Let's look at the life of a family law case. Next slide, please. Of course, when you go into court as an advocate, it's so important that we are aware of what is the run-up for the period. You get to court, we see what it's like in a courtroom, but what's actually happened before you go to court, before you get to court. And I'd just like to be able to go through those. First of all, it's important that any pre-proceedings involve negotiation. There will be negotiation at the door of the court, and we'll be talking about that in a moment. There will be mediation, and in many cases, mediation is compulsory. I say compulsory because it puts an obligation on the part of the applicant to attend mediation. It isn't compulsory in the sense that the court will expect both parties to attend, although there is suspicion that that's going to happen in due course. The separated parent information programme is something that's an option available. In fact, the title is now different because the title is just since the beginning of April, the court have made an order that, the court have changed the programme through Cafcass, that the programme is going to be different. It's changed slightly, and the way it's organised. But the purpose of the separated parent information programme still stands. It may have a different title, but the idea is to educate the parents on what's involved in a children's case. So in other words, are they child-centred? It is still voluntary, although there is some suspicion that that's going to be taken away. And then, of course, you have to think in terms of what pre-proceedings is. What about funding? When a client comes to see me and this is what they want, remember, funding has to be from the client personally. If you're dealing with care cases, you may get legal aid. But in most other cases, unless it's domestic abuse, funding is not going to be available through that process. So the client has to think carefully, do I really want to go to court because of the costs involved? And when you get to court, it may be that you'll be saying to the client, we can run this case, we can go through base 1, 2, and 3, but ultimately you will have to bear the costs. And the court are not likely to force the order to force the parties to pay your costs. So it's not a question of I won the case, therefore they pay costs. In family proceedings, cost orders are very rare. Next slide, please. What about when we get to court? Next slide, please. Well, as an advocate, we need to be aware of the fact, of course, that when we get to court, then you will need to report to the usher. And we'll look at the usher in a moment. Next slide, please. Courts, family courts are in private, and therefore there's not a public gallery. So clients can be reassured that they're not going to have people looking on. The only people who are allowed in court are specifically the parties and witnesses and maybe an interpreter. Next slide, please. All court hearings are recorded. So whatever you say, the court will record it, and you'll be able to get a copy of that if necessary. Next slide, please. When you get to court, there will be people that you will be coming across. And I'll show you a few slides in a moment on this. But first of all, you have to go into court and go through a security check, similar to what you would have at an airport. Court lists will be on the board as you go in, but it's likely that your client's name will not be on that list. It will be a court number and not the name themselves, because it's confidential and it's private and so on. The court has an usher whose job is to direct how the case has gone. So if you report as an advocate, what you need to bear in mind is that once you know where the court is, which court is going to be hearing the case, then you'll need to find the usher and report, I'm Stuart Barlow, I represent the applicant in this case, my client is here. And that's why the courts, in so many courts, will say, first thing you do is report to the usher. There will be interview rooms where you can see the client, your client, on the morning of the hearing, or indeed any other witnesses. Like most courts, interview rooms are at a premium. Some courts are better than others. A court clerk is there to sit in front of a circuit judge. A legal advisor is there to advise the magistrates on the law and procedure. Next slide, please. This is the typical security, and at all courts, you'll be expected to do that. So as an advocate, you still have to go through the process. Some courts, like Birmingham, I can think of in particular, where you can go into a court, a family court, and it takes so long to go through security. There's usually a big queue up the road getting people through security. Next slide, please. Waiting area is really important. All courts have a waiting area. And if there isn't an interview room available to see your client, sometimes you end up by speaking to your client in a crowded waiting area. I try, if I can, to keep clients away from the waiting area during discussions. But of course, waiting areas can be very busy, and therefore, ultimately, you just need to be very sensitive to the needs of the client. I tend to sit with clients during the waiting, if I can, in order to build up confidence. Next slide, please. Negotiations. When you get to court, negotiations are a very important part of resolving a case. Financial, private children, care proceedings, domestic abuse, cohabitation issues. There will always be a period when you get to court. So what's the process? The process is you'll go through security, you'll find the where the case is going to be heard from the notice board, you'll find the usher and report in, and having done that, the client will sit in the waiting area. And I often sit with a client in the very early stages if I'm doing a case, particularly if I've never met the client before, and I take them through the process. This is what's going to happen. This is the audit that you'll be seeking. And then I'm going to meet with the opponent. And the idea is to negotiate. Negotiate maybe on the terms of the order, maybe negotiate in terms of what directions you're asking the court to make. But the client often is left alone. And what I often do as an advocate is say to a client, I'm going to now talk to my opponent. I'm going off to a particular room to do that, and I'm leaving you. What I will say to you is I will not discuss matters that you're not aware of. In other words, I won't agree to anything unless you've agreed it to or are made aware of it. So they feel assured. Sometimes I point them in the direction of a cafeteria, if the court's got a cafeteria and so on. But the important thing is, remember, it's their case, not your case. You are the advocate, you are the messenger, but ultimately it's so important that they feel part of that process. So having entered into negotiations, I then go back to the client and say, this is what is discussed, this is what we've agreed, are you happy? And of course, if they're not happy, then it may be that further discussions and negotiations will take place. If you're the applicant, the onus is on you to drive those negotiations. It's what you are seeking. And try and agree the terms of the order. If you can't agree the terms of the order, agree the direction in which the case is going, what directions are to be made, so that when you go into the court have got a good idea of what the parties have arrived at. Next slide, please. Before we move on to special subjects, I'll give you an example of a case that I was involved in some years ago, in which I learned a big lesson in terms of clients. I was asked to deal with a client. I'd never met him before. He was appearing before the court on a family case, and he was described to me as a difficult client. And I decided that what I would do is, when I get to court, I wouldn't speak to the client first. I would go and speak to my opponent, who I knew. And I thought it would help in the advice that I would give. And so I saw the opponent. And as I went through the waiting area, I could see the client. I identified him. Well, I didn't realize that he'd identified me. And I went and spoke to my opponent, arrived at an agreement, which I thought was satisfactory. And then I was going to speak to my client, not as a fait accompli, but in order to help the process of negotiation. Within, I think I got about 10 feet from him, and he shouted to me, "You're sacked." And I didn't know what he meant. And he then said, "If you don't have the courtesy to speak to me before you go and speak to the opponent, I don't want you to represent me." And my conclusion of that was that he was absolutely right. I had made an error in terms of the way I acted as an advocate and as a representative of that particular client. I managed to persuade him that I had made a mistake and I apologized. But the point of telling you this story is this, that when you get to court as an advocate, whether you know them or not, the client is the most important, and you must, if possible, speak to the client before you speak to anyone else, even the usher, because they need to realize that they are being looked after and they are not being forgotten. And once you've done that, then you can make a judgment as to how long you spend with the client and what you do in terms of negotiation. But I hope that you will probably learn from what I describe as a pretty serious error on my part. And I like to think that I've never made it again. Next slide, please. Just a number of issues as an advocate. We've talked about finding of fact hearings. And I just want to pause on finding of fact hearing, because they can arise quite frequently in all sorts of family cases. They arise in terms of private children, where there's a dispute as to whether things have happened. It could be in care proceedings, where there's maybe non-accidental injury, and the court need to decide on who's caused those injuries. It could be domestic abuse, where one party makes allegations against the other, and the court, before it makes a final order, has to decide on whether certain facts are true or not. And it's the current position is that finding of fact hearings have become quite common. And one of the reasons is that we have a lot of cases in family proceedings now where we have litigants in person, where they simply will not accept certain things to be true or otherwise, which they're entitled to do. And so when you get to that first hearing, the court has to decide whether there should be that finding of fact hearing. And so in private children cases, Practice Direction 12J is the large authority. And there will be a split hearing. In other words, it's a hearing in its own right. It's not there to decide on whether, for example, contact is going to take place. It's there to decide on whether the allegations are true and if it has any bearing on the matter to a final hearing. So there will be a Scott schedule, in other words, a list of allegations to which the respondent can give a reply. Statements can be filed and so on. I mention changes ahead because there have been one or two cases more recently where the court have had to say that it could be that the process of finding a fact hearing is going to change. For example, are Scott schedules adequate in terms of determining the case? Scott schedules tend to be a list where certain things happened on a certain day, whereas the court is saying sometimes behaviour can be over a period of time, and therefore Scott schedules aren't the appropriate way of dealing with it. We're in changing times. As of now, Practice Direction 12J is fit for purpose, and that's what the court are looking at the moment. But if you're dealing with a private children case or a domestic abuse case or a care case, finding of fact hearings will crop up. And as an advocate, you need to be aware of that and what to do about it. Next slide, please. Expert evidence is another area which will come up from time to time. So if, say, it's a financial matter and the parties can't agree on the value of, say, a property or a company or a pension, you may need to instruct an expert to help the court on that. But parties simply can't go off and make instruct experts. They need to, if they're going to call them to give evidence, ask the court for permission. And the court will need to be satisfied that it's necessary. Why is it necessary to obtain a valuation on a property, even if the parties can't agree? And of course, you would be making an application as an advocate for a Part 25 order, where the court need to be satisfied that it's necessary to have one, that the instructions are given jointly. In other words, they are effectively neutral and independent. Now, of course, what sort of experts would you instruct? And it does vary enormously. So dealing with financial matters, it could be that you're dealing with a valuer, valuing property, pensions, and so on. But in children's cases, it could be that you'd be instructing a psychiatrist to determine the mental health of a particular client, or a psychologist about the behaviour of a client, the capacity to instruct you. More simply, it could be that the dispute over paternity of a child, and therefore you need to have a DNA test to determine whether that particular father is in fact the father. But one of the major issues, particularly outside care proceedings, is who's going to pay for the expert. And there can be big arguments at court over who's going to pay. So in a care case, it's usually covered by legal aid. But in private proceedings, so you could have a financial dispute and the parties maybe split it 50-50. On the other hand, in private children, one party may say, well, I don't want the report, I'm not going to pay. The court may have to decide on that. But it is fairly complicated. So as an advocate, you need to have at least some plan of action if you're going to instruct an expert to determine who's going to fund it. Next slide, please. In private children's cases, largely, is that we've been through the process. So you have a safeguarding letter between the application being filed and the first hearing. And at that first hearing, somebody from Cafcass will attend. And it could be that at that first hearing, the court will decide that a more detailed report is required. So therefore, under Section 7 of the Children Act, a report is ordered. And so Cafcass will usually be actively involved. Now, what I'd say to you as an advocate, and it's just worth mentioning, is that if you have a Section 7 report and you don't agree with it, and you want Cafcass to come along and give evidence, then you've got to make sure that there is an order saying that they should attend, because in normal circumstances, they won't attend. So you need to say Cafcass should attend to give evidence. If they don't, the court will accept the report in its entirety, because courts tend to follow the Cafcass report. What's the involvement of a local authority in the Section 7 report? It's when a family is actively involved or has been recently involved with a family, and they're best placed to be able to file a report instead of Cafcass. So again, when you go to court and you're asking for an order, first of all, you've got to justify it. Is it necessary? Secondly, who's going to do it? And the preparation for that is really important. Next slide, please. As an advocate, if there's one area that you need to be very much aware of, is the bundle of documents. Let me explain what I mean by that. And this applies to finance, private children, care proceedings, domestic abuse, and so on. The court will operate on a bundle of documents under Practice Direction 27A. So when you get to court, the court will have, all being well, a bundle of documents. So the judge or the lay magistrates will have their own copy, and the parties will have their own copy. And if it's a contested hearing, the witness box will have a copy in it. And as an applicant, you are the person that would deal with that as an applicant. So if you are acting for an applicant in relation to any financial matters, the burden of preparing and filing and presenting that document falls to you. The only exception is that if the applicant is a litigant in person, then you, as a legal representative, will have to prepare the bundle. And the bundle is essentially all that the advocate uses. And so if you think in terms of what's the purpose, is that first of all, the purpose is to allow the parties to know exactly what the case is about. That there are no surprises and nobody is presenting evidence before the court, and you're not able to present any evidence unless it's in that bundle. And so when you're preparing, you will know that the court in normal circumstances will not hear any evidence unless it's in that bundle. But there are rules, and the way that the bundle is prepared is, first of all, there is a maximum of 350 pages. That page restriction can be extended with the permission of the court. But it normally doesn't create a problem in, say, private children cases, domestic abuse. It's likely to be more of a problem in financial matters, and it's more likely to be a problem in, say, care proceedings, but it's extendable. And so the way it's formatted, so that you've got dividers and so on, they are set out in Practice Direction 1227A. Most of the stuff that I'm talking about now is in your notes. So it's filed at court and served on the other parties. Sometimes you can be a little bit picky by saying the applicant simply prepares an index and the other party has to get all their papers together if it's a paper book. But sometimes bundles can be done on the system, and But I've always taken the view that with paper bundles, if you are preparing paper bundles, then why not prepare it for the other side? Particularly, of course, if they're a litigant in person. I did a case only a matter of weeks ago where my opponent was a litigant in person. And the first question the court asked the litigant in person, who was actually the applicant, was, have you had a copy of the bundle? They, to my relief, they said they had, because sometimes they get missed in the post and so on. And if it's a contested hearing, you mustn't forget to take a witness bundle so that you can put it in the witness box during the hearing itself. Next slide, please. Why bundles are so important: to place it before the court all the relevant material, to give the advocate the best prospects of preparing, to assist the judge in pre-hearing, to enable the hearing to proceed smoothly. So let me illustrate that by the way it works. Is that I'm for the applicant, I prepared the bundle, all the parties have got a copy of the bundle, and then I call my client. I first of all introduce the case by saying, my name's Stuart Barlow, I act for the applicant. And I first of all say, has the court had a copy of the bundle? Yes. Has the court had an opportunity of reading the bundle? Yes. In which case, I can just address it by saying this case and can keep the introduction short. I then put my client in the witness box and I ask them to refer to the bundle. And I say, could you turn to page number 44? Yes. So turn to page number, is that your statement? Yes. Can you turn to page 54? Yes. Is that your signature? Yes. Are the contents of this statement true? Yes. Is there anything else you want to add? No. And that is essentially the evidence. You wouldn't normally be allowed as an applicant to produce any further evidence. And the thinking behind it is, well, if it's further evidence, the parties ought to be aware of it in the beginning. Courts can give permission to say more, but it doesn't normally do that unless it's absolutely vital to bring the case up to date. So you see, the bundle is really important. Next slide, please. I want to just say a little bit about litigants in person, McKenzie friend. Next slide, please. Because with a litigant in person, it's part of knowing your case. A litigant in person, I think the latest statistics are that in many children's cases, there's something like 30% of private children cases have both parties represented. So 70% or thereabouts of private children cases, lay magistrates, district judge, circuit judge, are unrepresented. So if you're for the applicant, as an advocate, you've got to be prepared to know how to deal with an unrepresented party. That in itself is a subject that can be dealt with in detail. But as an advocate, you just need to be prepared to be able to deal with a litigant in person, what the responsibilities are. And there's plenty of stuff written, including a book that I've written on litigants in person. What about McKenzie friends? McKenzie friends are simply friends who come along with the court to support them. They're not there to represent them. They can only go into court with permission. But there are professional McKenzie friends. You may have come across them. Again, it can be any type of family case. And if they ask for permission, they go in and they're simply there to give them moral support, to take notes, maybe whisper a bit of advice, but they cannot, in normal circumstances, speak to the court. The court can give permission to speak, but that is very rare. My notes set out quite a lot of detail about that. So it's litigants in person, McKenzie friend, very much common and need to be part of the thinking of an advocate. So we move on to knowing your case. Next slide, please. Preparation. You may say, well, that's pretty obvious, isn't it? You need to prepare. You'd be amazed how many advocates come and they're not prepared. I listened to a discussion between two barristers, and one of them sat as a recorder and the other one was an experienced. And they were talking about advocacy and talking about preparation. And the barrister that sat as a recorder, in other words, a part-time judge, said it's pretty obvious very early on whether the advocate is prepared properly, because all you need to do is ask them a couple of questions and they fumbling around with their papers and they clearly don't know the answer. And if they don't know the answer, we don't expect them to know the answer. They will give, I don't know. So preparation is absolutely vital. Let's look at that in a bit more detail. Next slide, please. General preparation. Can we move the slides through to the different, all the way through? Thanks so much. Great. So preparation is essential for any hearing. Interim hearing, it really is important that you know what's going on. And I've been in cases where parties don't know, and you find that the opponent is having to help the court with the information because the advocate didn't know. What sort of things are you looking for in terms of preparation? Be clear what order you're asking the court to make, because the district judge is probably going to say to you, so Mr. Barlow, what order are you asking for? It's not obvious from the paper. Or it is obvious from the papers, but I want to ask you to explain what order you're actually asking for. So what order? Has the court got the power to make the order? In other words, is it found in statute? And again, in my notes, I set out examples of the sort of things you'll be looking for. And is there evidence to support that? So by looking at your bundle, the court needs to be able to say, what order is being asked? What powers does the court ask? What evidence is in the support? Is it all in the bundle? Because if the bundle is in a proper order, you will go into a court and it will just move fairly mechanically through that process. Everybody's read the papers. It's a question of whether the order is appropriate. Next slide, please. Next slide, please. Family Procedure Rules 2010, very similar to the Children Act. In children's cases, those are the principles. Next slide, please. And child arrangements, if you're talking about a private children case, I just point out the fact that it's a really good practice direction, just to remind yourself. So it's practice direction 12B, 23 paragraphs. If you read that over a cup of coffee one night, every now and again, it's a really good reminder. And I do it from time to time myself, even though I've looked at it many times before. It helps you in terms of any private application to do with a child. Next slide, please. Next slide, please. Position statements and skeleton arguments. Could you sort of put all the various headings, if you would, please? Thanks very much. Position statements are very common in many courts. In other words, you're asking the court to make an order. What does the other side say? Position statements are there to help the court. It saves a lot of time. If you're for a district judge and you filed a position statement, then the district judge looks at it. Remember, he's got a big list. He's got a lot to get through. If he's got a very simple document setting out what your case is, then he will read it fairly quickly and probably have it in his mind when dealing with the case. If you don't file a position statement, then they won't have that. And therefore, the other party who hasn't filed a position statement is at a disadvantage. That would be my take, because it is a chance to argue your case. And when you're drafting a position statement, again, I'll put in the notes the sort of information that needs to go in a position statement. So it could be that in a contested children's case, the court will say, we'll set this down for hearing. And 7 days before the hearing, both parties will file position statements. And so, all being well, when you get to court, your position statement will be there before the court, and it will set out exactly what you're asking the court to do. Next slide, please. What actually happens at the hearing itself? Now, of course, it depends on the nature of the hearing. I said at the beginning about the types of court hearings. It could be a without notice. It could be a hearing, directions, case management. It could be a contested hearing. So much depends on the nature. So, for example, if it's a directions hearing, you will simply open the case. You as an applicant will open the case. But of course, you're not calling your client to give evidence because it's not one of those hearings, nor is there cross-examination. So you simply present the document or the content of a document by saying, this is what the court is being asked for. Now, of course, in a lot of cases, particularly children's cases, there are standard forms. And you simply, if you like, delete the bits that don't apply. And then you can tell the court exactly what's happening. The court will then turn to your opponent and say, so what do you think of what Mr. Barlow has said? And they said, yes, we agree with, or we've had discussions, etc. And the court will then, if it's a district judge or a lay magistrate, will then make a decision, yes, we agree with what's being said, or comment on it. And that applies to many, what I'd describe as procedural hearings. However, if it's a contested hearing, if it's, if you like, a stage 3 baseball game, then of course it's a contested hearing. And the format will take this form that me, as on behalf of the applicant, will open the case, will refer to the bundle, make sure everybody's got a copy of the bundle. I call my client to give evidence. We'll go through the process of them identifying the statement, and then your opponent will cross-examine. If you've got any witnesses, your client will step out of the witness box. The witness will go in and go through the same process, identify. Remember, witnesses need to have made a statement in advance. And once the witnesses give evidence, you say, that is the end of my case on behalf of the applicant. The respondent will go through exactly the same process. Submissions will be made on both sides. In other words, submissions are simply setting out your case and the decision of the court. And that essentially is the end of the matter. Next slide, please. Drafting of orders, I've mentioned the fact that drafting of orders is normally done by the applicant. CAP forms available for children's cases, I found them really helpful. You can put recitals in. In other words, sometimes recitals can be done at stage 1, 2 before final hearing. So in other words, what's been agreed, what's not been agreed, what are the issues, and so on. You put them on your laptop if you've got a laptop, send them to the court approve them. Undertakings can be quite useful. Say a party has agreed not to make contact with a child except for contact, and they of course need to be warned of the breach of any undertakings. But the responsibility for drafting the order is for the applicant. If you've got a litigant in person, sometimes the court will draft the orders, or the judge will say that, just to create a neutral situation. Next slide, please. I'm going to give you just a few tips on advocacy now and what the pitfalls are. What I'd done before doing that, I'd just refer you to the notes. The notes are pretty extensive, and I just deal with 1 or 2 headings following that. Tips and pitfalls. First of all, dress correctly. Many years ago, I came back to the Midlands and I went to the local magistrates court. There was a particular solicitor who was perfectly competent. He used to wear a sports jacket rather than a suit. Now, I don't make any big issue about that, but he just stood out. And people saw him as not as a good advocate, but the bloke who was underdressed, if you like. And I thought that was really sad, but the situation was a reality. So drawing attention to yourself by being incorrectly dressed can be a pitfall for you. And sometimes a judge will, if you're wearing, for example, a really bright tie, I've heard of a judge saying, "I can't hear you because of your tie," and so on. Seems ridiculous, but just dress correctly, usually for blokes, dark suits and so on, and just be tidy. Obviously, a lot of women in the East Midlands wear black suits of one kind or another. Prepare fully for the hearing. We've addressed that. Can't emphasize that too much. Arrive at court early so you can speak to the client and your opponent. Don't just roll up if the hearing's at 10, just turn up at 10 to 10 thinking everything's going to be okay, and it won't. Get there early. I know one particular barrister that I know is often my opponent, will be there really early. It's got the thing about being there early, but partly to grab a room, an interview room, but partly to just make sure that he's on board with everything. Find a meeting room for discussions if you can. Introduce yourself to the opponent. Write their name on your pad. I did a case not so long ago where I was for a parent in a care case. The local authority instructed counsel, and she stood up and said to the judge, "I appear on behalf of the local authority, Mr." And then she didn't know my surname. She knew my Christian name. And so the judge said, "Would you like me to tell you what Mr. Barlow's surname is?" It was so embarrassing. And for weeks and months afterwards, she kept saying to me, "I feel so embarrassed." So something simple like that, just know who your opponents are and able to introduce them. Keep your client informed throughout the whole process. I mentioned that earlier. Ensure that you address the bench correctly. Remember, your worships or Sora Madam in Magistrates Court, judge for district judge, your honour, circuit judge, my lord if it's a high court judge, and so on. I went to Manchester a few years ago and was told about this judge that corrected a solicitor because he called the circuit judge sir, and then he asked him to go and see him after the hearing and just ticked him off. So they can be quite sensitive about that. Most judges aren't like that. They can be a bit sniffy sometimes. So I wouldn't worry too much about that. But if you get it right, there's no problem. Make sure your court bundle is in correct form if you're the applicant. And if you're for the respondent, exactly the same. During the hearing, speak slowly and politely to the court and to your opponent. Don't get into arguments, particularly with your opponent. It just doesn't reflect well. In court, never become argumentative, show exasperation, or become angry. I mentioned about the fact that seeking advice from a lay magistrate before I started doing advocacy on a serious basis. And one of the things he said to me, he said, and he mentioned a particular advocate, he said, if we don't decide what the order, the way that he wants, he gets really cross and slams his papers around and storms out of court. He said, for me, that was one of the worst examples of a good advocate. And he was an experienced advocate. He just had this tendency. And I've always thought about that sometimes magistrates make decisions that you don't like, but getting angry and exasperated does not reflect on you as an advocate. So that brings us to an end. I just want to mention just one or two things. In terms of drafting effective position statements, someone's raised that. That's page 24 in the notes. Conducting oral advocacy, I mentioned about doing that. Negotiating at the hearing. I've talked about the different areas of work. I think I've covered most things. We've got time for a couple of questions if you want to be able to do that. But thank you very much for coming. I hope you found it helpful, and perhaps see you again sometime. If there's a course that you particularly want me to focus on, happy to do that at any time. I do this on a regular basis. So thank you very much. And I'll just show you a few books that I've written on the subject. Perhaps in the next slide, please. one on grandparents, one on working with litigants in person. Next slide, please. And then the one on advocacy. And up to date, I've just written a book which is due to be published by Law Brief on running a family file, which is a much medium, bigger piece of work. So look out for it if you're interested. Thanks very much. Any questions? Always gratefully received. Thank you.
Thank you very much, Stuart. That was fantastic. I'm not seeing any questions so far, just a couple of thank yous for you, Stuart, from Amber and Susanna. So just give it one more minute in case there are any more questions. If not, we'll draw it to a close, and feel free to forward any questions on to me, and I can pass them on to you as well, Stuart.
Thanks so much.
Okay, I think that's it. So thank you everyone for attending, and thank you, Stuart.
Thank you, Helen. Thank you, Eloise, for your help, and I'm glad the slides worked out well. And I'll be in touch. And it'd be nice to have copies of the feedback. That would be useful. Thanks very much.
Absolutely. Thanks, everyone.
Okay, thank you, everybody.